Ladies and gentlemen, could we have the audio up a little bit with a little bit of reverb, because it's the end of the day, we need some drama, we need some volume, we need to draw back the attention of these wonderful delegates who have given their whole concentration through the day. I'd like to say one thing, that competition law has never been more significant for the world, with the services sector taking the lead and more closed doors which are not apparent on the surface appearing in the world of business. It is absolutely essential for us to meet at platforms such as this. I'd like to invite Mr. Ramji Srinivasan to take the lead and give the address of the valedictory session. But before that, we have here with us Mr. Gopal Subramanium, Senior Advocate and former Solicitor General of India. He's going to be giving the valedictory address. We also have with us Professor Richard Whish, Honorary Queen's Counsel from the UK, and of course Mr. Atul Dua, the Honorary Secretary of the Competition Law body that has been set up. So may I please request Atul to give a bouquet of flowers to Mr. Gopal Subramaniam. And may I request Ramji Subramaniam to please give a bouquet of flowers to Professor Richard Whish. So with that, I'll request Ramji Srinivasan to take the mic and to conclude the day's events. There have been discussions that are both within the sector and from an external perspective. The sessions have been filled with wonderful, bright minds, and there is an energy which still keeps us all buzzing at the end of this day. Ramji.
It's almost 6 o'clock in the evening. It's been about 12 hours since I woke up. Did I say wake up? I spent half night only thinking about this conference, which is going to happen, and I don't think I really slept. But we draw to the close of an eventful day today, and I find that I'm so delighted to have seen such great participation in this third International CLBA conference, with active participation from all the members of our young bar, all the firms, all associates, and our gurus, if I may say, who have also been so generous in their time to spare from their busy schedules to join us throughout the day at the various sessions. It's been a great learning experience. Ladies and gentlemen, I would request you to please welcome today at this finale, Professor Whish and Mr. Gopal Subramaniam will address you at the valedictory session. But before I call upon them, I would only want to very quickly do a quick rewind of the day's proceedings. We started this day with the inaugural, and we had Dr. Abhishek Manu Singhvi speak up, discuss what his experiences were. We had Mr. Sikri, the chairperson, frankly speaking and candidly mentioning that there is a long way to go for the commission, and that he was happy being the recipient of not just bouquets, but also brickbats, which is actually the role of a regulator, because it isn't often that he can please everybody, and there has to be somebody who is. But he also made welcome remarks about the participation that CLBA has done, including the fact that he was associating all of us in the ICN as NGAs. And I think we must express our gratitude to the Commission for having taken such an encouraging role for the members of this young bar. Most of you, in fact, several of you I know for a fact myself, have all been students of Professor Whish, and I think each of us has a proud place in our bookshelves of his authorship of various editions. And I can at least count, and speaking for myself, I have all your editions, including the latest one. Thank you very much, Professor Whish, for joining us today. Thank you very much, Mr. Subramanium, sir, who is my guru, and under whose tutelage I learnt the art of law. I have still a long way to go to come anywhere close to what his footsteps lead me to, but I'm so glad that he accepted my invitation to also come and address all of you youngsters today. Not that that means that I feel myself very old, notwithstanding the gray hair. I must also then take you to the fact that Mr. Kher addressed this morning in a very open and thoughtful manner about what his experiences were sitting as a member of the Compat. He drew from his experiences as Secretary, the Ministry of Commerce, the international trade that he had engaged, negotiated for India, and also over the last years. He said that he was proxy counsel, but I'm glad to say he never took an adjournment this morning. So that is what he would, but I think, sir, thank you very much for having joined us this morning and having been with us, including to the close of the day today. We are grateful to you, sir, for the accommodation and the encouragement that you have. We had Ms. Kapoor, who joined us through the day in proceedings elsewhere. In the morning session, we had Justice Enlaw, who also spoke very clearly about due process, enforcement, and what the view the High Court had of tribunals generally. And that was also very enlightening. We had participation of Justice Mittal from the CCI during that proceeding, also apart from the lawyers. The merger control was chaired by Mr. Mittal, and I must express my gratitude. It was very incisive, as it was with participants from various leading law firms, international as well as domestic. And in the technology sessions, Mr. Bunker also made some great remarks as he chaired and steered that session, an extremely important session in today's time. We also had the Sectoral Regulators Conference, which was very interesting. And I must thank Mr. Rakesh Nath, ex-member of the APTEL, and Mr. Kuldeep Singh, ex-member of the TDSAT, both experts in the telecom as well as the electricity field, together with Mr. Machendranathan from the ERA, who had participated in those. Last but not the least, I must thank all my members of the Competition Law Bar Association, who so enthusiastically joined us in every session today. You haven't let me down. I'm proud of you. Thank you so much. And all the members and the partners and the associates and the young interns who worked very diligently, put together every small little detail to make this a success. Thank you very much. I must also mention one other thing. This was a program that was conceived by us some time back. It took us some time to put together all of this. We had great discussions on what the structure should be. But ultimately, what was unprecedented about this is that we got together the Competition Commission, we got together the Compat, we got together regulators, we got together lawyers, and we got together our international guests who have come in and flown from far and wide to participate, to share with us their thoughts. And I'm extremely thankful to each one of you who have taken the trouble to join us, accepting our kind invitation. Thank you so much. Everybody was open and frank, spoke their minds, but in a participative manner. And I think that goes a long way. I have promised that at the end of this session, the CLBA is going to produce a document which will capture each of those sessions and the suggestions that have been made by all the members. And that will hopefully be useful while the CCI proceeds with its amendment of regulations or to come up with circulars or guidelines, etc., for going forward. Last but not the least, while usually the vote of thanks is done by my very able friend and Secretary CLBA, Mr. Atul Dua, I will take this opportunity to thank him for all the work that he has done silently behind the scenes, and his team, Dr. Agarwal, Ankush, Karan, and all the others who all worked very hard behind the scenes. It is not easy to put together something like this. With these remarks, may I ask Shivani now to do the next steps. Thank you.
Thank you, Ramji. Well, you said thank you to Atul and his team, but actually he's very much a part of the team. He took over the Competition Law Bar Association presidency about a year ago, and within the year they have put together this conference. And of course, it's the dynamics within the team and also the visionary who leads the team. So thank you for this wonderful occasion. And now I'd like to invite Professor Richard Whish. He's the Honorary Queen's Counsel. He was Professor of Law at Queen's College London. He taught at Bristol University. He was a visiting Professor of Law at the University of Europe in Bruges. And he was a non-executive director of the Office of Fair Trading. He is a qualified solicitor and was a partner at Watson, Farley and Williams for 9 years. Of course, he continues in his role as a consultant, but he also is the recipient of the hugely prestigious Global Competition Review Award for Academic Excellence. So I hand over to Professor Richard Whish.
Well, good afternoon, ladies and gentlemen. Many thanks to the Competition Law Bar Association for the invitation to be here. It's an enormous pleasure for me to be addressing this audience. I've just been counting you while you've been looking at us. Well over 100 people in a conference theatre late in the afternoon on a Saturday. It's fairly remarkable. And I assume it's not just because you couldn't go shopping with your 500 rupee notes and your and your 1,000 rupee notes. And so the idea was that I would just say a little bit about where the competition law system has now reached in India. And I was wondering what to say, and it occurred to me, here we are in 2016, and it occurred to me that my first visit to India was in 1986, 30 years ago. A long time ago. I've been back about 85 times since because I love the country so much. But 30 years is a long time ago. And I remember going to Higginbotham's in MG Road in Bangalore to buy my copy of the textbook on the Monopolies and Restrictive Practices Act of 1969, which I have still got to this day. It's almost impossible to understand because it was modelled on our Restrictive Trade Practices Act of 1956. And I've also got a photograph from 1986 of myself with rather a lot more hair than I have today and wearing a profoundly embarrassing pair of dungarees, which I suppose must have been fashionable at the time. They certainly aren't now. But the photograph is of me in Delhi in front of the Monopolies and Restrictive Practices Tribunal, and I've still got that photograph as well to this day. Anyway, I've been a frequent visitor. I was excited when the 2002 Act was passed. We then had that very frustrating period, the phony war, where for 7 years nothing actually happened, but you've now been going for 7 years. And so we can begin, as it were, to take the temperature to find out how things are going. And it's quite interesting to look at you and compare where you have got to with other authorities when they were at a similar stage in their lives. And on that point, our Competition Act in the United Kingdom came into effect in 2000, and I was appointed to the board of the Office of Fair Trading. That's the predecessor to today's Competition and Markets Authority. I went on the board in 2003 and was a member of the board until 2009 for 6 years. So I was on the OFT board at exactly the same stage that the CCI is at now. That is to say, 6-7 years in. And I must say, actually, when I look at what's happening here in India, what I see developing is pretty much what I would have expected to see happen, actually, which is that one has got a certain steady flow of cases have gone through the system. Of course, I am aware that there have been procedural setbacks. I think the last year has been particularly noticeable from that point of view. I well remember at the same stage in the life of the Office of Fair Trading when it suffered a series of procedural setbacks. And all I would say about that is I think it's inevitable when you have any new system of law. Everyone is feeling their way. And I think the really important thing is, insofar as there are setbacks, as long as everyone learns from it and can move forward, I think it's almost part of growing up, as it were. So I would say that there's been steady progress, there are challenges, but I would describe the situation, I would say that the foundations have been laid and the building is beginning to appear above ground, but we're not there yet. I look forward to the day when there's a kind of a steady throughput of cases. I don't think we're quite there yet, and I'm going to say a little bit about that in due course. Now, some of the things I'm about to say are not India-specific, because I have to say competition law has been very kind to me. It's given me an extremely interesting life, and one of the things I do is to visit numerous other countries, especially where there are new systems of law. And in recent times, I've been in Argentina and in Hong Kong and in South Africa. And some of the things you see happening, you see exactly the same things happening in other jurisdictions as well. There are certain kind of systemic issues that come up globally, and I can see some of these things are happening here. So in what I'm about to say, some of these comments are not India-specific. They're rather based on experience of what I see as I go around the world. And Mr. Srinivasan there was talking about, we've got the CCI here and the Compact, and we've got the regulators and the private bar. Funnily enough, I was going to make a very similar point about what it takes to have a well-working system of competition law. And I would describe four key parties: government, the competition authority, the court system, and the private bar. And so what I'm going to do is to say a few words on each of those four dramatis personae. So I'm describing here a quartet. And of course, a string quartet can be a very beautiful thing. If you've heard a Schubert string quartet, you'll know that it's melodic, harmonious, very soothing, and very gentle on the ears. If you've heard a quartet by Schoenberg, you'll know it is the complete opposite. It's grating, and it can be quite painful to listen to. So the question is, in India, what kind of quartet have you got? Are you more Schoenberg or Schubert? Let's come back to that at the end. So a few words on each of these people. The government. Obviously, the government is key to all of this. It's the government that proposes the legislation. It's the government that decides whether and when the legislation needs to be changed. And I would say, broadly speaking, looking at the 2002 Act, I think it's pretty good. There are things I wouldn't necessarily have drafted in quite the same way, but when it comes to the key substantive rules, which is what we're ultimately interested in, we've got the expression appreciable adverse effect on competition. I see nothing wrong with that. It's economics-based. And we've got abuse of dominance, and there's plenty of experience out there in the wider world as to what is meant by abuse of dominance. So I think the legislation basically is fine. Of course, there are issues of interpretation that still have to be addressed. I know the current issue about whether under the Act it's possible for the CCI to investigate an individual at the same time as the enterprise. Well, any legislation will give rise to these kind of issues, and ultimately they get litigated. Ultimately, the Supreme Court has to decide, but there's nothing particularly unusual in any of that. And I don't think there's any magic in the words of the legislation anyway. What ultimately matters is the quality of the public authority, the proper assessment of evidence, and reaching decent conclusions. So I think the legislation's fine. Some of the countries I go to in the world, what I find is that the problem with government is that the government wants to control the authority. This is a very, very live issue in some countries where the government actually politically endeavours to manipulate what the competition authority is doing, tries to get the authority to do its own bidding. I could name countries where that is a problem. I'm not going to name them. I don't want to embarrass them publicly. But as far as I'm aware, this is not a problem or an issue in India, which is great. But the other thing that government is responsible for, of course, is resources. And one of the things I find incredibly frustrating in many of the countries I go to is that the government has adopted the legislation, it's created the competition authority, but then it doesn't give the authority the resources that it needs to do its job properly. And I see this in country after country after country. And as and when I am engaged in discussions with people in government, in the ministries, even the ministers themselves, I try to explain you can't do competition law on the cheap. Doing competition law in practice from the authority's point of view is very complicated. And in particular, these cartel cases, you're mostly from the private bar, but when you're on the other side of the table, when you're the competition authority, and you believe that there's a cartel and you've got to work out whether there's a cartel or not, there is vast amounts of evidence. You're hearing lots of conflicting stories. You're hearing lots of different views from different participants, etc. And I always liken this to doing a jigsaw puzzle. And you give to your child a 50-piece jigsaw puzzle, and then when he or she is a bit older, it's a 100-piece. It might ultimately get to 400 pieces, and you do the straight edges, and that's it. And it's relatively straightforward. Some of these cartels are phenomenally complicated, and I think that they are more analogous to a jigsaw puzzle composed of about 1 million pieces. And for an authority to do these cases, they really do have to have decent resources. And this can be a problem for the competition authority in, say, Mauritius or Barbados with small populations, but name me a country, quite frankly, that is more complicated than India. An astonishingly complex place. And I would say, and this is not being said because of any discussions I've had with the CCI, just objectively looking into India, I just don't see that this authority has as many resources as it ought to have to be able to do its job in the way that the government intends it to do. And I just thought I would share with you an experience from the United Kingdom, from our Competition and Markets Authority, formerly the Office of Fair Trading. Let's say that the CMA today has a budget in the region of, let's say, £50 million. What the CMA does at the end of each year is try to evaluate the benefit to consumers from the interventions that the CMA has made. So if the CMA discovers a widget cartel and it brings the widget cartel to an end, in a rough and ready way, it says, well, what was the cartel price? And if we eradicate that cartel, how much a price is going to go down? I'm not saying as scientifically as in a quantum action for damages in a court, but in a rough and ready sense, how much have we saved consumers through this cartel intervention? And I think one can do that. And then there are the mergers that get prohibited or sometimes modified. Well, if you're modifying or prohibiting a merger, it's because you've got a theory of harm. And the theory of harm, in the end, is likely to be that this merger would have led to higher prices. So in a rough and ready way, you can work out what gain to consumers has been achieved by the merger intervention. And the OFT and now the CMA has done this for a number of years, and I'm sure that some people might look at the number crunching and be skeptical as to how robust it is, but in a rough and ready sense, the CMA reckons that for every pound it takes to fund the CMA, it returns to consumers something in the region of £10. So a ratio of 10 to 1. A return on your investment of 1,000%. Well, if you're the government, committed to competition policy because you think competition policy achieves benefits for consumers, and if for every pound you are saving consumers £10, that seems to me to be pretty good public policy. Not least because if the consumers have now got those £10, it's £10 that they can spend and put back into the economy. So if you look at this in a macroeconomic sense, it seems to me that there are gains to society from competition law and intervention. And I suppose the reason I'm sort of saying all of this out loud is, insofar as authorities have to go to their government with a good case for more resources, isn't this perhaps the best way of making the case? I can show you, I can achieve gains in precisely the area that you want. And here are comparative exercises from other jurisdictions. So I think that's something interesting to think of. Second part of the quartet is the Competition Commission. And here I'm talking about the public body that enforces the law. Well, resources. I've already discussed resources. The authority has to have resources. Another very important issue for public authorities, and I see this problem everywhere I go in the world, is that the bright young things come in from the National Law School after their master's course and they work in the public sector for 3 years. After 3 years, they're beginning to know what they're doing and they're now of value to the organization, and that's when they go into the private sector to get a salary 10 times higher. And it's an immensely frustrating thing. I don't think I've ever been to a country anywhere in the world where I didn't come across this problem. So there is a serious issue to be thought through by all institutions as to how to achieve staff retention. That's just a systemic problem. But the thing I've been at terrific sessions today listening to the debate, leniency. I just think this leniency issue is so crucial to a successful anti-cartel policy. And I just want to say a few words about that. You've got your regime, it's in the legislation, you've got the regulations, and so on. And I heard the Secretary of the CCI describing your system here, and what I heard here is actually extremely like what we have in the EU. So number 1 goes in and gets immunity, numbers 2 and 3 can get a reduced fine, so let's call that leniency. I heard a debate about whether number 4 and number 5 can get anything. That's a detail. I won't go into that for now. But you've got a regime pretty much like ours. And just one statistic to share with you is that over recent years, and this is absolutely clear, you can go through the European Commission's decisions and show empirically that this is correct, more than 90% of the cartel cases in Europe originate with a whistleblower, which is another way of saying that we probably wouldn't have an effective anti-cartel regime without the leniency program. It's absolutely critical. It's the glue that makes everything stick together. So more than 90% of cases came from leniency. 2 of the others were not in a formal sense because of leniency applications, but they were cases where an employee of one of the cartel companies was angry about something and decided to tip off the European Commission, not because they were trying to achieve any personal gain. I gather in one point it's because a lover had dumped him and he decided to complain as a reprisal. But the point I'm making is that even there, the authority was tipped off as to what was happening. So leniency is crucial. But there's something interesting in the Indian system, which just reminds me of what happened in Europe. We introduced a leniency regime in 1996. And that regime said that if you went to the European Commission and asked for leniency, the Commission said, we might give you a reduction of your fine. We might give you a reduction of the fine, and it will be up to about 75%. And frankly, undertakings, the language we use in 101 and 102 in Europe, undertakings weren't attracted by that. Am I going to blow the whistle in the knowledge that I might get a reduction of up to 75%? And frankly, it didn't work. And by then, the Americans had changed their system, and we adopted the American system, which said if you're number one, if you are the immunity applicant, then unconditionally you will be given immunity, and that immunity will be 100% of the fine that you would otherwise have paid. And that's when the floodgates opened. Automatic, unconditional, 100% immunity. Now, I know you don't have that here, and I am aware that there are arguments the other way, but I'm just wondering out loud whether the unconditional 100% isn't a better way of doing it, because it's all about incentivizing people to blow the whistle, and if that's what it takes, that's what it takes. There was a sense in Europe when it was 75% discretionary. Part of that was because at public policy level, there were some member states who felt it's great if people blow the whistle, but cartelists have done something wrong. They have breached a moral norm. And if you've breached a moral norm, you should be punished. Even if you've blown the whistle, you should be punished. So that's a kind of a moral approach to these things. And then in the end, when the Commission realized it didn't work, they said, no, let's go the whole hog. It may not feel nice to give somebody 100% immunity, but just being purely pragmatic about things, if that's what it takes to get people to blow the whistle, well, you know, swallow hard, close your eyes, but that's the way to do it. And whenever I'm teaching this subject, I always describe what I call the virtuous circle. If competition law, specifically if anti-cartel is going to work, you have to have high penalties. And then if you've got high penalties that hurt, you will then get leniency applications. If you get leniency applications, you will discover cartels. That will lead to decisions, and they're decisions that impose a high penalty. That, I would say, is the virtuous circle. And without the high penalty and without the leniency regime, I'm afraid the competition authority is always going to be fighting an uphill battle. But I just thought at this stage I'd mention something else about India, which hasn't really kicked in here yet, but it will do in due course. And that is the so-called follow-on action for damages. Because what now happens in Europe is every cartel decision of the Commission will be followed by a damages claim. As night follows day, there will be follow-on actions for damages. And in some of these cases, the damages may be for phenomenally large amounts of money. We've just had a trucks cartel fined in Europe where the fines were 2.93 billion euros, the fines, and there's one company yet to be fined. But I read an estimate of the likely harm to customers caused by a 14-year trucks cartel, and one person has estimated that the harm to the road hauliers, the freight forwarders that purchased the trucks over a 14-year period is likely to have been in the region of 98 billion euros. 98 billion euros. I see the senior advocate's eyes light up because, of course, this is where the this is where the lawyers come in. There's a lot of money there to be recovered through the damages action. And I mean, it is very interesting in Europe because we now have a claimant bar. Historically, the big law firms acted and still act for the defendants. But there's no point acting for defendants unless there's somebody to act for the claimants. Somebody once said, there's no point in being the only lawyer in a Midwest town. You need at least one other lawyer to have a business. And mercifully for the defendants' lawyers, the claimants have moved into the London, Brussels, Düsseldorf markets. And so there are firms now like Hausfeld that specialize in representing the claimants in these cases. Quinn Emanuel would be another. Stewart's Law would be another. There are novel forms of funding coming onto the market to fund these kind of claims. You can insure yourself against the possibility of having to pay the defendant's costs if you're unsuccessful. But how does this relate to leniency? Well, it relates to it in a very significant way. The authority wants to incentivize the members of the cartel to blow the whistle, so we have to think, I'm advising the cartelist, I have to think through all the risks. Well, there's the risk of the fine that might be imposed if I don't blow the whistle. Of course, there's another risk, which is I'm going to be sued for damages. And there's no immunity from a damages suit. So by blowing the whistle, you are exposing yourself to a damages claim. And then a problem is, if you were to submit to the authority a written document explaining the contours of the commission, that may be discoverable in follow-on litigation for damages. And so there's quite a subtle thing to be thought through here, how the private and the public claims fit together, and more specifically, whether leniency could be subverted by inappropriate handling of the leniency application by the public authority. So it's just one to think about. One other thing I was going to say on this whole area, leniency, etc., is if you have effective leniency, and if that leads to a steady flow of cases with very high fines, the best way to teach corporate society about competition law is to have a steady flow of cases. Nothing educates business better than reading cases, the schadenfreude of seeing that your competitors have been fined large amounts of money. And so what I'm saying here is if all of this is working well, it will cause ultimately companies to realize they have got to have a competition law compliance program. And having a competition law compliance program doesn't just mean having a file, ticking a few boxes, and then putting it in the filing cabinet. Having a compliance policy means instituting the policy, educating everybody, repeatedly re-educating everybody, trying to get an active buy-in to what's going on, and ultimately, hopefully, it will achieve its effects. The specific thing I wanted to say about the UK is that in 2016, there have been 2 cases where the offenders agreed to pay a fine, and the CMA specifically reduced the fine by 10% in return for a commitment by the firms in question to implement a competition law compliance program. I've never seen that anywhere in the world before. So the authority actually saying we would have fined you $1 million, but we will fine you 900,000 because you have agreed to implement a compliance program, and then what those undertakings have to do is submit an annual report to the CMA itemizing all the acts of compliance that have taken place, all the training programs, when, where, etc. So it's just an interesting development, and I wait to see what more comes of it. Another thing, two final things to say on leniency. One is, just to show how important this is, last week I was actually in Argentina, which seems quite a long way away now. And the reason I was there is that Argentina at last has decided to give flesh to the Competition Act. It's been on the statute book, but ineffective. And there's a new president in Argentina, and he passionately believes in competition policy. He wants to see this law working, and there's a bill in Congress to do the necessary to make the law work. And one of the key provisions of the draft bill is the creation of a leniency regime in Argentina. They haven't got one at the moment, and this is the government saying to Parliament, give us a specific hook on which to hang a leniency policy. A different point, which may seem to almost be contradicting what I'm saying, is that I don't like a situation in which competition authorities only ever catch cartels where there's a whistleblower. Because if you think about it, this is kind of dangerous. If the authority becomes entirely dependent on people blowing the whistle, I can see the argument that says that actually reinforces the cartel. Because what we do is we have a cartel meeting and we say to each other, you know, as long as none of us ever blows the whistle, they're never going to catch us. So I think what an authority has to do, if it possibly can, is to find other ways of detecting cartels, maybe by having economic intelligence units or whatever. But I think a smart authority has to be able to sometimes to find a cartel on its own initiative. But it is not easy, and I'm not pretending that it's easy. So that's the Commission. And then, much shorter to finish off, courts, and then you yourselves. The courts, you have to have a robust system of appeal. And you have to have a court equipped with the right resources to be able to do its job. And you've got Compat, and there are specialist people in Compat, not only lawyers. But one thing that does strike me, I mean, I do follow what's going on in India, and I realise that some cases are taken to the Delhi High Court and other cases go to Compat. And I understand absolutely why that is the case. Indeed, the same thing can happen in London. You can seek a judicial review of the CMA's decision in the High Court, or you can appeal a decision to the Competition Appeal Tribunal. So I understand why it's like that. But I really do find myself asking, is this a sensible way of doing business? I mean, it seems to me that for the lawyers, there's a wonderful way here of playing certain kind of games, because ultimately one wants to delay everything for as long as you possibly can. And when I see this thing, is it High Court, is it Compat, how do these relate to one another and whatever, it reminds me of Bleak House by Charles Dickens, and in particular the litigation in Jarndyce and Jarndyce, where the litigants are litigating over a disputed will and an estate worth a large amount of money, and the question is whether the case should go to the Chancery Court or to the Court of Common Law, and they litigate it for about 47 years, and by the time the litigation is ended, all the fund in the estate has been exhausted on legal fees, and nothing positive has been achieved by any of it, other than for the lawyers, of course. And I just find myself wondering how sensible this is. And I've not spoken to anyone in India about this. I'm just saying this for the first time off the top of my head. But query, could there be an argument for saying anything that is disputed on the part of the CCI should go to Compat, where the expertise in competition law resides? Our Competition Appeal Tribunal now has 3 chairmen and 12 members. And those members are lawyers and economists and accountants and business people. Furthermore, every judge of the High Court is able to act as a chairman in the CAT. And I was lecturing them, actually, about 6 weeks ago, and I looked around the table at the quality, the experience that that court has now got in competition law. It is absolutely formidable. I think it's an admirable institution, and that is where these cases now go. So I think that's an interesting thought. One thing I'll add about our Competition Appeal Tribunal, because this is a distinction between you and us in the UK. Under, I think it's section 53 of your Act, if there's been a finding of a cartel by the CCI, then the victims of the harm can sue for damages. That's a follow-on action. But you only bring your damages claim after the CCI has made a decision. In other words, you don't in India have a standalone action. If I think I'm being abused, the CCI is the gatekeeper. The CCI is the monopolist. Unless the CCI acts, there's nothing I can do. But since the 1st of October of last year, our Competition Appeal Tribunal, it's always been able to hear follow-on actions for damages, but it also now has a standalone jurisdiction. So if I consider that I am the victim of an abuse of dominance, I could go to the CMA. Alternatively, I can bring a standalone action in the Competition Appeal Tribunal. And this has fundamentally changed legal practice. I would say it's actually fundamentally changed the competition law picture, because the CMA doesn't have the resources. I come back to resources again. The CMA doesn't have the resources to deal with every complaint that comes to it. Even if it wanted to deal with every complaint, It could not do so, and it has enforcement priorities criteria, and it will select big, high-profile, big-ticket cases. Well, a lot of the people who claim they're the victims of abusive dominance are probably quite small entities in quite narrow markets, and the CMA is never going to be interested. So the CAT was given this standalone jurisdiction on the 1st of October last year, and here we are just over a year later, and they've already had 6 of these standalone claims, 2 of which were started and almost immediately settled. So the claimant threatened the action in the CAT, and the defendant then changed its behaviour, and a settlement of some kind was reached. So I think that's quite an interesting idea. I have no idea whether the time is ripe for standalone actions in India. I understand why originally they were not allowed. Competition law is new. You need a specialised authority to do the investigation, and then the damages claim comes later. The new law in Hong Kong is the same. The law in South Africa is the same. But I would think that certainly after a period of time, when everyone has matured, learned what's going on, query, does a time come when a standalone action might be worth thinking about? The last thing I'll say about the private bar, this is after all the Competition Law Bar Association of India's event. In my harmonious or disharmonious quartet, the private lawyers play an absolutely crucial role as well. And this is not, I stress, this is not a point about India. This is a systemic problem issue that I see everywhere in the world, which is that in many countries, you've got the authority and you've got the private bar. And basically, they are parallel universes. And I see many lawyers in private practice that quite simply regard the local competition authority as the enemy. They are hostile to business. They don't understand what they're doing. They're infringing our human rights. I hear sometimes they're all a bunch of idiots. I mean, some of the things I hear said in some jurisdictions I find really quite shocking. And it is as though the whole world is divided between Montagues and Capulets, with periodic warfare and the occasional death. And I think this is an incredibly unfortunate situation to get into. It seems to me it's kind of born out of a certain kind of cynicism. There's an awful lot of cynicism in the world today, and it's profoundly unhealthy. It's cynicism that led the population of the United Kingdom to vote for Brexit, and it's cynicism that caused the citizens of the United States to elect President Trump as its president. There's just too much cynicism in the world. And I suppose what I would say to private lawyers when they are getting angry with their local competition authority, just stop and remind yourselves that the authority is there to protect the public interest. Cartels are bad. They're particularly bad where the cartel is one facing members of the public, very often the poorest members of the public. I've come across cartels around the world for candles, where people have to buy candles to light their homes, bread, sugar, salt, taxi fares, bus fares, etc. I mean, this is wicked stuff, especially when it's being inflicted on poor people. The competition authority is actually there to pursue the public interest, and it's not just normal private-to-private, business-to-business litigation. There's something much more sophisticated going on here. So I entirely understand why representing a client, one will want to represent their interests robustly. But what I would say is it's really important that there should be mutual respect between the competition authority and the private bar. And too often I go to countries where I think that mutual respect is lacking, and I think it's very unfortunate. In lots of countries you have the revolving door, whereby people go from the authority into private practice, but also where sometimes people from private practice go into the public authority. But in most countries, it's not a revolving door. It's people who start in the public authority and then go into the private sector. I think it's healthy sometimes if people from the private sector then go back into the public sector, and then you build the mutual respect. Thank you very much.
Thank you. From Ayn Rand in the morning to Charles Dickens in the evening, from the Honorary Queen's Counsel to the equivalent of the Queen's Counsel, but not just any senior advocate. Thank you so much, Professor. Mr. Gopal Subramanium was actually the youngest ever senior counsel to be designated by the Supreme Court of India. But firsts are not unique to him. He was one of the first people to be there when the CCI case, the first CCI case was presented before the Honorable Supreme Court of India. In 2009, he was the Additional Solicitor General from 2005 to 2009. And at that point of time, the President of India conferred upon him the National Law Day Award for being an outstanding jurist. He became the Solicitor General of India in 2009, along with being the chairman of the Bar Council of India. And of course, as a senior officer of the law for the Government of India, he had many greats to his credit. He was involved with various constitutional and criminal issues, including being a prosecutor for the prosecution of Ajmal Kasab, who was the only surviving terrorist of the Mumbai terrorist attack 8 years ago in the very month of November. He has been applauded by the likes of Mr. Fali Nariman for the bar entrance exam, which was his initiative, and the list goes on. However, I think I will have to refrain from indulging in anti-competitive law, and I will have to step back and request Mr. Gopal Subramaniam to give the valedictory address.
Thank you, Shivani, for, I think, a litany of, shall I say, extraordinary extravagances. Professor Whish, my very dear, distinguished friend, colleague, Ramji, Srinivasan, Atul Dua, and distinguished ladies and gentlemen. I heard Professor Whish with great interest. He is obviously a very accomplished writer, speaker, authority on competition law. Competition law is obviously a subject which has more recent origins as far as India is concerned. But we need to place this in some context. The first is that we have a constitution, and our constitution is a written constitution which bears limitations on the state. It means that you have an elected government which is accountable to the people, but which is also meant to subscribe to the ideals of the constitution. One of the ideals is about an equitable allocation of social resources, protection of the underprivileged. And shall we say somewhere, the moral purpose of the competition law is to be found really within the Constitution, which prohibits any kind of unequal treatment. I think the foundation really starts with the directive principles. We had a law called the MRTP Act, an act which I'm afraid was very badly drafted, but even more poorly implemented, that it became simply a matter of, shall I say, farcical remembrance for both lawyers and judges. And at last, we had a standing committee which decided that we must update ourselves with a modern competition law. But a modern competition law will succeed only when you have a competition policy. And you must have a political theory to a competition policy. One of the problems in the Indian context, and possibly the Competition Commission never spells it out, is that we don't have a clearly articulated competition policy. We don't have a clearly articulated political theory. We don't have a practice that policies go through Parliament, which I'm very happy to notice that the UK High Court very recently insisted that Brexit must go to Parliament for its approval. The only other instance in India when a court insisted that policy must go to Parliament was when the Delhi High Court insisted that telecom privatization or migration must go to Parliament. So parliamentary approval is indeed very necessary, and I think the kind of obscurity which attaches to the absence of a clearly formulated competition policy approved by Parliament is one of the severe defects, because you don't really have an anchor for the purpose of dealing with the competition law. So you have a second best, which is you have concepts, most of which are derived from legislation abroad. I agree that we have the most wonderful phrases, appreciable effect on the Constitution. We have also abuse of dominance. We have a series of factors. As one of the learned members said, ex ante, post ante, you have a host of considerations which are extremely well described in the statute. But how do they work in reality? I think that's a very important question which we need to flag. First of all, does the Commission have enough resources to study the market itself, not simply the competitors? Because when you need to study the competitors, you need to study the market, and the market as a whole. And that requires resources, that requires a multidisciplinary approach. I have been an advocate of multidisciplinary approach, not only in relation to this tribunal, but in many others. And I think the purpose of a multi-member tribunal was to have a multidisciplinary composition who would bring in their relevant expertise and would institutionalize it, and you would have a very variegated, but perhaps a more or less accurate response to a complaint. The purpose of competition law, again, is not to prove itself by big-ticket success. That is, in other words, you start with having to prove you exist because you must prove that there are cartels. That is really not the way in which any institution must begin. It must derive information as legitimately as a court does, because it does replace a court. Whether we like it or not, I don't think that due process can be minimized. I don't think it can be said that the bar is versus the Competition Commission. Not at all. What I think is important is that there must be a respectful understanding that the way in which lawyers actually expect adjudication of matters in court simply needs to be replicated by the Commission without the delay, from the start to finish. The competition lawyers who are today trained are prepared to finish their matters from a start to finish model. But of course they need assistance, they need encouragement, and they also need the understanding from the Commission that they have a role to play to represent the interests of individual clients whose legal rights are in jeopardy. Now, if we do not really understand that individual rights of litigants are in jeopardy, the fact that it is a big-ticket case, or it is called a cartel, or it is called abuse of dominance, does not take away from the very nature of guaranteed due process under the Constitution. I must tell Professor Whish that one of the great arguments against tribunalization in India has been that you are lopping off whatever pillars of actually investigating and adjudicating due process is. And one of them is that you tribunalize by an opaque process of selection to tribunals persons who you claim are experts but are not really experts, but who might be able to be in alignment with governmental thinking of the day, and you have them as tribunals. Now that is a very torrid question, and we have not found answers to that question. The answer to that question can only be found in the quality, as you rightly said, the quality, the enormous public credibility which the Commission and the Tribunal will bring to bear in the discharge of its functions. And I must say in fairness to the Commission, and I wish to acknowledge it publicly, that I do see that there are many orders by the Commission which reflect a great deal of investigation, a great deal of understanding, effort, and I see that there has been a proper application of mind. So it is not possible simply to say that the Commission cannot coexist with our expectations or the expectations of constitutional adjudication. But that has to be a foundational pattern. So our quartet, which you spoke about, very much like Schubert's quartet, is founded upon the fact that litigants can be permitted to be represented by lawyers without being oppressed. They must not feel oppressed that a public authority is going to give them a short, shoddy hearing. And that is a complaint which has been repeatedly heard. Now, the fact that the Commission is not used to it, well, we all train ourselves. None of us studied competition law when we started our practice at the bar. We were students of constitutional law. But we all delved into it and tried to find